Ready? Awesome. Thank you all for joining today. We've got a really amazing panel set up by one Allison Chaikin, who's in the back. I want to point her out. I think I'm getting undue credit for the idea of putting together this panel and the very eloquent introduction that was written for it. I think it's a really important topic. One of the things that I'm very interested in is, many of you may have heard me talk about my pacemaker defibrillator. I have a heart condition and I have a pacemaker, and I can't review the source code in it. So I joke that this is an issue close to my heart. And, and one of the things that I have discovered through my journey of finding out about software and its safety and understanding how vulnerable it is that it's not just any one area. It's not just pacemakers, it's insulin pumps, and it's not just insulin pumps. When I learned about cars, this really floored me. I just couldn't believe, I hadn't really thought about it like so many people. And so I think this issue is one that is incredibly important and is only going to get more so. And so the panel that we've assembled here today is a perfect group of people to sort of talk about the tension between what happens when you want to have free and open source software in something like cars, but you're balancing that with safety and security. So maybe if we could go down the line and have everybody just introduce themselves a little bit and talk about their, where your expertise intersects with this field.
Hi, my name's Matthew Garrett. I work for a cloud company called Nebula, which isn't particularly directly relevant to today. So we'll ignore that. I previously was at Red Hat and did a lot of the work in implementing secure boot support on Linux, the UEFI secure boot protocol. And I'm very interested in both source code availability in terms of license compliance, but also in terms of user freedom and the ability to maintain user freedom in a world where we are starting to think of a shift towards appliance-based computing and trying to balance the freedom to have end-user modification against devices that are intended to perform a specific purpose.
Hi, I'm Greg Olson. I'm with the Alliance Consulting Group, and we work in the areas of helping companies and businesses use open source software productively. The reason I'm on the panel is that I work on the license review team with the Geneva organization. Geneva is a consortium of automakers and supply chain companies in the automotive infotainment industry. And so that's actually the forefront of open source finding its way into the arcane world of the automotive supply chain, simply because you can't do much in multimedia without encountering open source. And so we're pushing the envelope a little bit in terms of what the automakers are understanding and willingness to engage in collaborative open software development.
I'm Bryant Wicker-Smith. I am a fellow at Stanford University. I teach, write, speak on the legal aspects of vehicle automation. So far in the future, the cars that drive themselves. I think that my value to this panel, I hope, is coming at the automotive perspective and the tension in law with respect to uncertainty. So I'll take the position that automakers are very astute, and when they understand risks that they can reduce to costs, that's easy to manage and make decisions. It's when there's uncertainty about the extent of exposure, the extent of restrictions, that innovation really starts potentially suffering.
Hi, I'm Richard Fontana. I am a lawyer at Red Hat. A lot of my work at Red Hat focuses on open source and free software licensing issues. I think, and I've been at Red Hat for about 5 years, I think I'm primarily on this panel because of the work I did before Red Hat when I worked with Karen at the Software Freedom Law Center. At the time, I was heavily involved in the drafting of GPLV3, including the provisions that probably the automotive industry would be most concerned about with respect to GPLV3, what are sometimes called the anti-Tivoization or anti-lockdown provisions.
Thanks. So this is I'm looking around and I recognize a lot of faces. I know this is a pretty savvy room. So I'm going to skip the basic, does free and open source software make sense, in cars question, and go straight to does GPLV3 make sense in cars? And who would like to start on that discussion? So maybe.
So this isn't so much me providing my opinion on something, but it's a question that I think should be asked of Richard right at the beginning of this discussion. And that is, does the anti-Tivoization clause of GPLV3 actually apply to vehicles?
Yeah.
Can you actually, Richard, can you start actually by explaining the very basic idea behind the anti-Tivoization provision? Because I think while it's a really savvy crowd, I know that a lot of people get confused by the different license provisions.
Yeah, so there's a provision in GPLV3, Section 6, which says that if you distribute a binary, you have to provide corresponding source code. That's the first half of the section. There's a whole other half that says if you're distributing a binary in what's defined as a user product, which is basically a consumer product as defined under the U.S. Magnuson-Moss Warranty Act, so a consumer device based on U.S. case law interpreting that statute. You have to also provide any information that is necessary for a user to take the software and perhaps modify it and then be able to install a functioning modified version on the same device that the user received. Is that sufficient?
So now can you?
Oh, to answer Matthew's question, I think it depends on the vehicle. I think probably an Army tank is probably not a user product under GPLV3, but I think an ordinary what I guess in the U.S. at least we call a non-commercial vehicle, so a car that you would personally own, that is certainly a consumer product under the Magnuson-Moss Act, and so by at least legislative history, as it were, that would be a user product under GPLV3. So I think unquestionably, an ordinary consumer grade car is a user product.
And do you think it makes sense to treat it as such?
I think there is a case to be made. So I understand what the concerns are in some of the concerns in the automotive industry about using GPLV3 licensed software in infotainment systems in cars. They're basically related to liability and safety issues. I could imagine, and during the drafting of GPLV3, this issue was discussed. I could imagine a different version of GPLV3 or an exception to GPLV3 that might carve out categories of user products that are, subject to particular kinds of safety regulatory regimes that could include cars and other kinds of equipment. Does it? So, I mean, I suppose it makes sense. On the other hand, it could also make sense from the consumer's point of view, from the car owner's point of view, to be able to modify the software running in the car, much as a consumer is able to modify the hardware in the car. But that ability to modify the hardware, to change your tires, for example, is subject to regulation and so forth. So in a certain sense, my view, I suppose, is that software and hardware should probably be treated the same way. There may be an issue with GPLV3 in that it doesn't clearly, at least if you look at the text, it doesn't account for the existence of regulatory frameworks that might make it difficult for provision of the ability to install modified software in your car, in the same way that there is a regulatory framework for what kinds of tires, what size of tires you can put on your car and so forth.
Do you think that that part of the GPL would have been written a little bit differently now, or would you have recommended that? This may sound cheeky as a question because I was also at the Software Freedom Law Center at the time, two doors down. but I'm actually, it's a genuine question. Do you think that it would go differently now?
That provision itself was a compromise. It's maybe not remembered today, but the earlier versions of public versions of the GPLV3 draft, which had were attracted a lot of attention at the time, originally had very broad provisions that applied to any distribution. So basically, distribution in any kind of hardware device, whether it's a consumer device or not, that would require you to give the user the ability to install modified binaries that would run on the same device. The FSF, which was our client, made a compromise working with, or in discussion with industry vendors, where those provisions would only apply to a subset of consumer devices. So it's important to understand the history that the FSF was giving up a lot in making that compromise. Whether today, the compromise would be, if it were being drafted today, the compromise might be to just sort of make it optional or opt-in. Maybe that would make some sense today, I suppose.
Matt, do you want to comment on this since you asked the question?
Okay. So one other aspect of the anti-Tivoization clause that seems to be kind of generally understood is that while it must be possible to replace the software, it's not necessarily required that the device then function in an identical way to its previous function. I think one example that was given was, say, having an LED that would be a different color to indicate that perhaps by replacing the software, the device is no longer in a supported configuration for warranty purposes. And we could perhaps imagine that something equivalent could be done for indicating that the system meets regulatory requirements, and that should someone replace the software on the system, we could construct systems in such a way that they would then have to be recertified before you could have the car claiming that it met regulatory conditions, in much the same way that if you have your car certified and then replace a set of parts, it may be out of certification, and the next time you're required to have your car checked, this invalid configuration would be noted. So it doesn't seem like there is necessarily an inherent conflict between the idea of GPLV3 and the freedom for end-user modification and meeting regulatory requirements. I think we should probably try to ensure that we don't phrase it in such a way that the GPLV3 is seen as making it impossible for someone to impose constraints upon the software running on cars. Say, and I think that most concerning cases, not so much necessarily the in-vehicle infotainment, but certainly if we had self-driving cars based on GPLV3 software, I think people would have legitimate concerns about end users being able to modify that software and then it being legal to run those modified cars on the roads without anybody verifying that they still behave correctly. I don't want software I write to be driving a car I'm sitting in. So, for the most part, I don't want software written by arbitrary other Linux kernel developers controlling cars I'm sitting in or that are around cars I'm sitting in. So I understand the concerns here, but on the other hand, we have this idea that throughout Linux development, we've seen that there can be a great deal of innovation, and the ability for people to perform these modifications is something that can drive progress, technological progress. And if we made it difficult for, say, university students to modify cars and then use those modified cars in closed courses for testing purposes, then that would perhaps make it much more difficult to get this kind of technological development. So I think we do need to concentrate to an extent on trying to find a way where we can figure out a way of avoiding this, the license prevents innovation without compromising on safety.
So, Greg, you have a lot to say about this, I know.
Well, I have something to say about it. We've had long discussions within the Geneva organization about the use of GPLV3. It is finding its way significantly into a number of different software areas, certainly around Linux and other software. So the issue here, I think, is as much about clarity as about any sort of technical issues. The fact is that you have to understand the automaker's point of view. And right now, they are dead set against it. Okay, it's prohibited.
Is anybody in the audience here from an automotive company? Okay, just checking.
Yeah, and their perspective is that they have a whole ecosystem that chases after them anytime somebody's car crashes and tries to names them on suits. And we've seen major incidents about this, but it's many hundreds of millions of dollars a year, I believe, on even the North American scale. That's a day in, day out affair. Okay, and so one of the ways that they've dealt with this is they built a very, very tightly constructed supply chain system that tests things very rigorously, controls all the parameters, and this is one of the ways that they limit their exposure to these sorts of situations. They know exactly what's in their vehicles. They test it as best as they can every which way. It's not like an experimental, innovative kind of world, and it's been very interesting trying to teach these automotive supply chain companies how to use open source effectively, because it is a different world. So they've got this very controlled perspective because it's the way that they've grown up and learned how to deal with this reality of people chasing them for money anytime something goes wrong. And so to them, this idea that you're going to allow people to compromise that control is very scary. And so their first reaction is simply no. All right? So what would allow that to open up more? Because clearly we're going to see more GPLV3. We're going to see some good things, maybe not the Linux kernel moving over, but a lot of other software will, because quite frankly, it's a better license than the V2. A lot of work went into making it a better license. So how do we deal with this? And one of the key issues is clarity. The boundaries of what anti-Tivoization means are not really crystal clear in the industry today. So I mean, we were just talking about some things. Can you void the warranty? Can you put up a display? The GPLV3 says that you can keep such a device off the network if you're concerned about it causing trouble there with protocols, for instance. Well, does that mean you can lock it out of the car's device network if it's changed? See, these things have not, there's no consensus, there's no clear lines in place. And so that makes this very risky to the automakers. They're investing, a car line is a billion-dollar kind of investment. And so they need to have very clear lines if they're going to make their bets along this and open up the door.
Yeah, you mentioned a lot of different points, and Richard, we'll get back to your...
I just wanted to make one
okay, why don't we have you respond quickly to that point, I think, about...
GPLV3, the relevant section does explicitly say that the distributor of the device can void the warranty. I think that part is...
Yeah, Bryant.
So I want to pick up on a point that both of you made with respect to certification and the current approach of manufacturers. Automotive regulation right now is very much based on the idea that you described of large companies with large reputational and liability stakes self-policing their vehicles. And that's not just a question of manufacturers, it's a question of government regulation. And there we see a real dichotomy where certification isn't going up to a government regulator and saying, well, let me show you my source code, or even let me talk to you about my code. The federal government has only very recently started recognizing the need to, or a need to, look at software as a critical piece of a vehicle. And so on the regulatory side, you have a question of entrance barriers, where states and the federal government act to make it difficult for little innovation or little manufacturer. And on the other side, on the user side, you have the complete opposite, where it's incredibly easy to get a license to operate a vehicle and to do whatever you want with that license. And as vehicle automation in particular shifts more of the driving decisions from a human who is not regulated to the vehicle, which is regulated through this reputational approach, it raises some tension with which direction you want to go.
So what is the current state of software review from in the automotive industry? I'm asking because, you know, in the medical device industry, there's a shocking lack of of review of the actual source code on these medical devices. Is it the same case in the automotive industry? I just don't know.
So there aren't, as I understand, individuals from automakers here, but there are certainly people from companies that are very involved in the automotive industry here. And I think that's an important distinction to make. I can't speak for individual companies' attention to their source code or to their software. There is a lot of consideration right now in the automotive context of what actually their level of robustness needs to be for software. So an example of that is ISO 42242, which is functional safety standard. Thank you, 26262. Looking at exactly that question, how much do we need to do?
Does anybody else have any other? So what about, you know, we talk about having indicators of modification of the software, but actually Allison asks, you know, is secure boot a viable option? Do you want to comment on that?
So secure boots are kind of the first example of something roughly equivalent to Tivoization turning up in the PC market, as opposed to the things that look kind of like PCs but are in a different shaped box, and so we pretend that they're not general purpose computers. But one of the distinctions between secure boot and Tivoization is that implemented in the manner that Microsoft currently require for certification on x86 systems, the end user is guaranteed the opportunity to replace the system keys and then to enforce their own chain of trust. And they can either replace those with their own keys, or they could replace them with a third party's keys. So we could imagine a scenario in which, say, the Free Software Foundation were willing to provide keys to Linux distributions that they certified as being 100% free software, and you could then configure your laptop such that it would refuse to boot any operating system that wasn't 100% free software. So the kind of user freedom here is relevant because it means that it has been demonstrated that the choice is not user freedom or security. But when we move on to something where it's less about the end user, where we're talking about cars, the freedom is not just the freedom to modify your own device, it's also the freedom of other people on the road not to be killed by your 2-ton death machine. I think that question becomes a little more complicated. I personally certainly believe that a secure boot type model where the end user could, through a series of explicit acts, cause the software on their system to be changed is beneficial to technological innovation and research. And I think the idea that research groups or individuals should be able to replace the software on cars in order to determine whether there is a better way of doing things is completely worthwhile. And an inability to do that makes it much more difficult for small businesses to break into this market. But that doesn't necessarily mean that I believe that such a system should provide an equivalent configuration such that it's legal to operate such a machine on the public roads.
Well, then there's also the question about, you know, about repairing cars over time, and, you know, whether or not, you know, baked into this mechanism is a monopolistic, you know, grant to the manufacturer simply because of these software limitations.
Certainly there is a risk that if it's not possible for the end user to replace the software, then you're going to end up with a scenario where it's also impossible for any third parties to replace the software. So say maybe an end user may not be qualified to certify that this new software is legal in terms of local regulatory requirements. It might be possible for a third-party vendor to do that work, to write the code, and to get appropriate testing done by appropriate government agencies. And you would think that it should then be possible for that third-party software to be installable on your car somehow. But I can certainly also imagine that the automotive industry is not necessarily particularly interested in that. You can see this. One case that springs to mind in terms of forward compatibility is the sheer number of cars that shipped with iPod docks, which, as of the new iPods, are almost completely useless because they're all 30-pin connectors rather than Lightning connectors. And so we've already got a kind of enforced technological obsolescence as the automotive industry's tried to adapt itself to a much more rapidly changing market. So I could imagine that it's not a big concern for them. I think we should try to find a way to make sure that it's possible. I think at the technological level, Secure Boot does provide one way. Equivalent technology to the ones used in UEFI Secure Boot might provide a way of achieving that.
So, Greg, what do you think about different security mechanisms in this regime in Secure Boot?
Well, there are a couple that are proposed. The real question is the unclarity about whether they're compatible with the GPLV3 or not.
So what are they? And we can maybe go through and put Richard on the spot.
Well, at one level, there's something like Secure Boot. So basically, if the software has been changed, the thing cannot run, whatever it is, right? And I believe that, let's get an opinion on that one.
I'm sorry, what's the
The
question?
The ROMs use a scheme like Secure Boot, and if the software's been changed, it doesn't let it run if the car doesn't run.
I'd probably have to study that more,
Okay.
so don't put me on the spot.
All right, sorry.
Is it it's an easy?
Good try. But yeah, these things are tricky, and this is
Do you
exactly
actually,
the problem.
it is a complicated question. Do you want to sort of talk a little bit about some of the what questions you would ask?
I mean, I don't think there's any easy, quick answer to those kinds of questions. GPLV3 has certain, so the anti-lockdown provisions in GPLV3 have certain exceptions built into them. They essentially, some of them say if no one has the ability to modify the software, if a third party or you upstream do not have the ability to modify, you don't have to give the end user the ability to modify. So that's one issue. I don't know if that doesn't answer the question, but okay.
Some of the other, sort of the other end of the extreme would be something that checks for modification of the software, checksum, CRC, whatever, and indicates on a screen, your warranty is void, and there's some kind of indicator in the car that the car maker refuses to be liable, and perhaps there's some regulatory environment eventually. The law is going to take probably 10 years to catch up with software here that says it's illegal to drive on public roads with uncertified software. That could be. But for right now, a practical thing would be to show in some clear way and indicate to the user that his car is unwarranted and he's driving at his own risk.
So this is what
Something
Matt
untested.
was talking about
Yeah.
before, like an LED or some indication. So.
Yeah.
And that's entirely consistent with GPLV3 and GPLV2 that you can, it's understood that you can tack on indications of, disclaimers of liability that are pretty much as broad as local law will allow, and there's a long tradition of that. And that's related to this idea that in a separate sense that you don't have any, GPLV3 says quite explicitly you don't have any obligations to continue warranty in the service sense or to not void a warranty if you are complying with the anti-lockdown provisions of GPLV3.
There was a question? Okay, great.
I'd like Matthew's point about, you want to allow experimentation, and an example of, I have a friend who built his own aircraft, it's experimental aircraft, and when you get in the co-pilot seat, there's a big sign that says, warning, this has been, and blah, 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 but he did have some certification that he had to get through in order that he can fly himself. So I could imagine on the vehicle side, you don't want to stifle experimental vehicles
So the audience member for the recording is saying that, giving an example of an aircraft that was that has a warning in it that says, that it may be modified, and that some level of certification is necessary.
And maybe there's restrictions for where experimental car vehicles could go,
Right.
or what they could do compared to one you bought.
Yep. Is,
I think one of the problems, I will say, with GPLV2 and GPLV3 is that they aren't very, so they don't say very clearly how the license requirements interact with existing local regulatory regimes. They're sort of, GPLV2 has its section 7, section 12 of GPLV3. This is often thought of in terms of patents, but it's really kind of a broader provision that has to do with the what happens if, for example, if a court order says that you can't comply with your requirements from a copyright license standpoint as a distributor of binaries under GPLV2 or GPLV3. And this provision is also in GPLV3. It's I think a little clearer in GPLV3, but it's still, I think both licenses could have gone further in clarifying what do you do in cases where there's a conflict between local regulatory law that that is generally applicable to all users or distributors, and the requirements of the license. That's something that has been kind of in a way swept under the rug, and maybe if you can imagine a future version of GPL, it might clarify what the nature of that kind of interaction. I don't know if that would help in this area, but I think it could probably help in the future for providing greater certainty to distributors and manufacturers of devices that are covered by provisions like Section 6 of GPLV3 in understanding what the what the risk exposure is.
does anybody else want to comment on this?
I would also say, by the way, aircraft is probably also a user product under GPLV3. They're under Magnuson-Moss case law.
Matthew, did you want to have something you wanted to add, or? Okay. Bryant. Yeah.
Just to reiterate that in the automotive realm, we don't have a solid standard with which to compare, a solid legal standard, that it is a self-certification. It is a law governed by product liability law, and that's been a recurrent concern of automakers looking toward user modification of their vehicles. There are several legislative provisions in different states specifically addressing the modification of vehicles to convert them into automated vehicles, and then the responsible parties in cases of crashes because of this concern. So I'm not sure the juxtaposition is with some sort of aggressive certification regime. It might be the disconnect between an obligation to allow modification and the foreseeable misuse that could be related to that, and that could be a basis for civil liability.
Are any of those initiatives ones that you would recommend? Are there any of the approaches ones that you think should be adopted more widely and be done on a broader scale?
I mean, academically, there's a big debate whether robotics generally should have open source rules of liability that encourage open source. And the legislative response has been fairly decidedly based on traditional tort law dynamics. So you see in a state like Florida, there was a provision that largely restated existing law regarding modification and liability, but nonetheless was desired by automakers, was opposed by trial attorneys. In California, that same provision was rejected. In terms of an approach, I'm agnostic. I would suggest clarity is more important at this point than resolution on one side or the other.
And you agree with that, Greg?
Yeah, that was my point. Someone has to make $100 million bet, at least, on this. They need clarity to even make a decision. And the default answer has to be, let's stay out of that. We don't know. It's too high risk. Now, there is one other thing I wanted to bring up here, though, and that's that this idea of modifying cars is not new, okay? I don't know. Has anyone here put a new engine control ROM in their car, speed it up? No? Well, anyway. Yeah, they are available. And you can, and the transmission controllers too. So if you want to make a hot rod, cars are all engine controlled now. You don't tune the carburetor with a screwdriver. You go get another ROM. And so this is something that already exists in the industry to some extent. Now, it doesn't mean that the car makers love it, but this isn't entirely new ground for GPLV3.
So, one kind of aspect that is probably not something that's been thought of that much within the context of cars yet, but which we have seen in other cases, is that if you tell people they can't do something, they're much more likely to do it. So Greg mentioned that there were kind of two ends to the scale. There's one where end-user modification is effectively forbidden, and then there's the other one where end-user modification is permitted, perhaps within some sort of legal framework. The risk is that if you you forbid modification at a technological level, people will modify them anyway. They will find ways of doing that because it's taken Apple a very long time to get to the point where they can make a phone whose software you can't modify. And I don't expect that the first few attempts from the car industry would be significantly better. So if you go for we don't have to worry about this from a legal perspective because we put technological measures in place to prevent this from ever happening, it's going to happen without there being any framework of laws to figure out whose liability it is then. If we could argue that perhaps the car manufacturer was at fault for not implementing the security properly in the first place, that could be kind of a problem for the car manufacturers. There's perhaps an argument that making sure that there is this legal framework, that there is this opportunity for end-user modification could protect the car makers more than just implementing technological protection mechanisms.
Okay, so that's a really good point of discussion. But why don't we had a couple of questions from where we were before, so. Oh, good idea.
Oh, thank you. This way she doesn't have to repeat it. Well, I've built up now one observation and two questions, so I'll race through this as quickly as possible while hopefully still being intelligible. First was we made comparisons to aircraft. This is a field I know a little bit about. I have some friends who are private pilots. It's a really different domain. The nature of the beast is very different. People don't drive on roads in the sky, and while there are airways, those are gone now, and they're mostly for commercial traffic. Pretty much everybody just uses GPS point to point. It's the responsibility of the pilot to avoid things. Most private pilots don't have traffic control services. They can request them. They may not receive them. And licensure for pilots is very different. Being licensed to fly, actually you don't have to be licensed to fly certain types of very limited aircraft. I've looked into this personally with powered parachutes. But if I want to carry a passenger, I need to be licensed beyond what I would need to be just to fly a light aircraft like a Cessna. So these are really different beasts, and I don't know that we can apply the same framework to those. Second point was a much simpler one, kind of a question. Might it be that the automotive industry has such control over its supply chain that this fear of GPLV3 is something of a stalking horse for wanting to keep control of that supply chain? That may be a rhetorical question. It may not be one that the panel is able to answer. And finally, the third point is much more broad and philosophical. What are the differences here between the automotive domain and the software-defined radio domain? I'm having difficulty thinking of anything that essentially distinguishes this case from the one where the FCC wants to be able to say what frequencies our cell phones can use. And cell phones have at least much penetration into the marketplace as auto. Maybe one of the few devices in the consumer marketplace that does. So I made a big deal about distinguishing aviation from auto driving. What I can't see is the distinction between FCC regulations over the airwaves and auto, given the consequences of EM interference. You know, all kinds of bad things can happen. People can die. Their pacemakers can fail. So the consequences are certainly as grave. How can we, or is there even a reason to distinguish these two areas at a software licensing level?
So maybe we should start with the second question first, since it's now fresher. Bryant, are you maybe the right place to start with
I think
this?
I'll leave that rhetorical.
Well, that was
Right.
the supply chain one?
Mm-hmm.
Oh, did you mean the...
Oh, the
Oh, I
second
meant to
question
actually
regarding
start with the
distinctions between. I mean, you make a very good point that both do have effects on human life. The one difference that I might offer up is acceptance of the status quo, where today driving is a very dangerous human activity, and yet we're pretty okay with that. And there's a difference between, at least conceptually, one driver drinking or being distracted and causing a fatality, and one person modifying their vehicle, that vehicle performing poorly and causing a fatality. One is going to make headlines, one isn't.
Both will, but one might make a national story.
Yeah, yeah, and unfortunately, both will be obituaries, but one will show up on the front page nationally. So I offer that as my first reaction, and you could probably come back and say, well, doesn't radio software raise the same issues? And maybe, but it's not maybe that close or emotional in that sense.
Matt, did you want to comment on this?
Yeah, so I think one other case is, you mentioned cell phones specifically. One thing that's true in the majority of the cell phone market is that even while Linux is now the most popular basis of an operating system running on cell phones, it's only typically running on the application processor. The radio is typically running locks down custom firmware that is signed with existing well-tested cryptographic primitives. And so far, attacking the baseband has mostly been of academic interest. That's beginning to change now that a lot of the low-level phone locking is being done in the baseband rather than at any other level. And so some of the original software unlocking of the first-generation iPhone was based on finding a flaw in the baseband's software validation such that it was possible to run arbitrary code on the baseband. So far, so I think part of it is that nobody's really thought of the baseband as being something that would be affected by GPL type requirements, because none of the software running there is currently under those licenses. So from a purely practical perspective, vendors currently aren't wanting to ship GPLV3 code on their phone basebands. They don't need to run Sandler there yet.
Well, the GNU radio people are thinking.
The GNU radio people are certainly thinking about this, and they're currently going to be hit from with practical constraints rather than legal constraints. And so I think one of the differences is that right now the systems running in cars are much closer to being general-purpose computers than the software-defined radio in most cell phones. And that may be different in some other cases of software-defined radios. So I think the cell phone analogy maybe falls down a little just on the basis of reality rather than conceptually.
Well, I think it does sort of touch back on that point that you initially made about, whether a legal regime might be preferable to technological ones.
Yeah.
And I was wondering, actually, if Bryant had any comments on that.
There's this great photo from, I think, about 1918 of this guy pulling an automobile with a horse. And you ask, well, why is this horse hooked up to this car? And the reason is that Nantucket had prohibited cars. And so the answer of the postmaster of the city, of the village, as it turns out, was to simply start pulling his car with a horse. I think just as we find ways around technological limitations, there will be ways around legal limitations, and both will be frustrated. So I wouldn't hold out either as perfect solutions, but I do agree that a legal framework that contemplates when technological barriers are overridden, and likewise technology that contemplates when actual use doesn't correspond to legal use, are both necessary.
Greg, do you maybe want to talk a little bit about the supply chain question that we had initially?
Oh, about trying to control the supply chain? Well, there's no question that the automakers try to keep control of their supply chain. And I don't think there's any way around that, in the sense that they're the customer, they write the contracts, they do control the supply chain, and that's the way it's supposed to be. They specify the tests, they negotiate the prices. It's a very, very controlled structure, as it must be to get a car manufactured at the target price using literally 1,000 different suppliers to bring all those parts in on schedules and assemble them. So this has to be controlled, and it's always going to be controlled as you know, it's the nature of the beast, if you will. The automotive supply chain is going to be controlled just like a factory is controlled. I don't think the automakers are averse to innovation in the supply chain. And in fact, what I'm seeing is certainly in the infotainment space, the automakers are members of Geneva. They want this to happen because they want the electronics in the cars to become compelling and help them sell cars. Okay, so they don't have an interest in thwarting innovation and experimentation and new things in the cars. As best I can tell, their only concern here really is civil liability, is the thing that is looming in their heads, as you'd expect if you were getting sued multiple times a day around these issues. It keeps being in the forefront.
Conceptually, shouldn't it be pretty easy to isolate the infotainment system from the rest of the car, such that basically all you're getting is telemetry from the operating system? That way, you have an interesting display about here's the timing cycle on my fuel injectors. That's probably not something they're going to offer us soon, but I can see the community being.
Because as soon as you get a display, you want to change something. Right? As soon as it tells you you're using this, and you think, well, I could be using that, so you want to change it. So,
well, if you don't have I/O pins back out to the engine to tell it to do that, then you can't.
So Greg,
you have to provide a mechanism for altering the operation of the vehicle via the infotainment system, and until there's demand for that, it's unlikely to happen. Right?
Well, perhaps, although there's another example.
Yeah. Would you like some? It works like that. I've done embedded software for servers for 9 years. It just doesn't work like that. As soon as you show someone some information, they want to know how they can change something. Even if it's just via the foot pedals, right? They want to know, if I do this, why doesn't it do that there? And
I'd like to use a gesture to refill my gas tank.
Okay, that's.
So I think it's a useful third question. Does an architectural boundary provide equal value to the two proposed already, which are technology barriers and legal barriers?
Do you want to?
Conceivably, sure. Now, I just want to talk to that point about the infotainment system separate from the car, the more fundamental control systems of the car. The example that keeps coming up in these discussions with the automakers is, well, what if the radio starts playing at 120 decibels? Somebody could crash and we'd get sued. There's another one that comes up is, what if the GPS tells the driver to turn left into a brick wall? So there are examples here that could conceivably create civil liability that they want to avoid. And yes, architectural limits can limit that too, I think. There are a range of remedies here. The thing that's a real problem is that nobody knows exactly what those boundary conditions are and whether they're okay with the GPL and what it will mean in a civil liability suit. That is what's causing trepidation here.
Richard, you look troubled.
Not troubled, but I think in a way this is a strange discussion because if I think what hasn't been said here is that the use of GPLV3 and GPLV3 family licenses in the open source and free software world has been significant but limited, and probably limited enough that the automotive industry can treat it as something that can be ignored or something for which substitutes can be found. I think if we'd be having a very different discussion, or maybe not even having this discussion at all, if GPLV3 were a hugely dominant license in the open source project world in a way that it isn't quite today. You know, let's say it's roughly 12% or so of open source projects by some metrics. If it were more like 70%, and I'm assuming that we're not entertaining any theories that GPLv2 has sort of implied anti-lockdown requirements. If it were dominant as a license, the automotive industry would probably have to come up with some sort of solution, whether it's architectural or sort of reassessing how they manage their civil liability risk exposure. In a way, this is sort of an issue that is resolved currently by two things, which is one is the limited use of GPLv3, and also I think the absence right now of as far as I know, from consumers of a demand to have the ability to modify the software in their cars.
Yeah, I mean, I guess maybe that's another sort of a good question to entertain is that, is there a demand by users to modify their cars? I mean, I heard Allison Chaikin give a great talk at Your Planet about the right to repair and about how this affects hobbyists, and then I also was referring earlier to other, to third-party, repair shops and other things like that. I mean, I think there's some confusion about what demand there is for users to modify their cars, but I think there is a strong one. You want to talk about that a little bit?
Well, I just think that I think that any industry is going to respond to the consumer demand. If the consumer demand to have the ability to modify the software in any kind of device is low, then the manufacturers of the device are not going to take it very seriously, or they are going to consider it a low priority issue relative to other concerns such as their risk exposure. If GPLv3 or similar licenses account for a small amount of software out there relative to alternatives under other licenses, then they can be ignored, and the problem is seen as sort of going away.
Yeah, I think my question was a little bit, I didn't phrase it properly. I think what I was touching on is sort of in the medical device industry, when I talk about who is the consumer of the device who might want to modify it, I would say that, as a patient, I don't really think that I'm actually targeted as the consumer in this instance. I have a defibrillator, but I think the doctors tend to be the consumers, not the patients. And so there's like a real disconnect there. I think there's a similar parallel in the automotive space.
Yeah, I think that thinking about this from a license standpoint, I think GPLv3 is sort of trying to anticipate how consumer regulation, this is sort of just true of GPLv2 as well, trying to anticipate what consumer regulation should look like. And it's sort of way ahead of where consumer regulation actually is. And I mean, that's how I've always seen the GPLv2, the basic requirement to provide source code if you distribute binaries. This is a kind of consumer protection mechanism. And that's even more explicit with GPLv3 and the anti-lockdown provisions.
So I think we have time for one more question. Is anybody else who hasn't asked a question yet? Thank you.
So I was wondering if you guys have any outlets other than events like the Collab Summit to discuss these type of things more privately. It seems to me that the industry itself won't actually push for these conversations to happen unless there's an actual understanding of the potential market gains of innovation with the community. But you can't have these discussions unless you have someone in the industry who understands the potential innovation and the possible market that you can actually tap by doing that. Now, you can't understand that unless you also have the understanding that you can likely solve these issues. And you can't really address that unless you have a belief that you can actually do that. And I think it is possible, but it doesn't seem like there's a healthy debate for this right now. And I'm just wondering if you guys have outlets to...
So where is this being discussed is the question.
Right.
Well, I can tell you it's being discussed at Geneva. The next members meeting is in Barcelona at the end of this month. It's a hot topic there.
User modification of vehicles is a topic of great interest in the area of vehicle automation. And that will get, I think, a fair amount of discussion this summer at Stanford's Vehicle Automation Workshop. And there's a day-long session on architecture, for example, of systems that bring up these questions. So I see it becoming probably more relevant as a legal question, as a technical question, and as a market case question as vehicles themselves get more advanced and the players broaden.
So I think we're actually out of time, but please join me in, are we? Yeah, okay, good. It was a little bit, anyway, join me in thanking the panelists. I think this is a very interesting discussion, and I hope that it carries on into other venues, and hopefully we'll have more discussion while we're here. So thank you all very much.